All right, hello. Um, People are coming in right now. I'm gonna just sit here silently for a minute or so to let people join up, and then we will get started. All right, it looks like we have a lot of the people in. I'm going to go through sort of some housekeeping here before we get into the actual presentation. My name is Samuel Spade. I'm a staff attorney at Homeline, also Homeline's Impact Litigation and Research Director, and this is going to be a CLE on breaking a residential lease. And I'm also here with Shannon Tomenes. And could you just take a moment to introduce yourself as well?
Hi, everybody. Shayna Temenis. I am a senior staff attorney at Student Legal Service here at the University of Minnesota. So I represent Twin Cities campus students, undergrad to PhD in housing and consumer issues. And I'm excited to talk about leases and breaking them today.
All right, so Homeline, we're a nonprofit organization. We provide free legal, educational, and advocacy services to Minnesota renters all throughout Minnesota. Um, we operate in four different languages, so our hotline is in four different languages: English, Spanish, Somali, and Hmong. You can call us in any of those four languages. You can email us in those languages as well. We've advised over 350,000 renters since 1992, which is when we started. We've got our phone numbers here, as well as the places that you can email us. And I also want to point out, you should hear this when you log in, but this session is being recorded. It will be available on Homeline's website in a few days. And if you have questions, which we hope you do, please ask them through the Q&A function located at the bottom of the Zoom window. You can also type it into chat if you want to. We will probably see it, but sometimes those get lost. So again, if you can remember to use the Q&A function, that would be particularly helpful for us to see and track and answer questions. And then last from Homeline, we've got another webinar coming up on May 20th about city ordinances. We're going to be talking about some of the changes to the Duluth City Ordinance, the Minneapolis City Ordinance, a lot of the changes to St. Paul City Ordinance, and cover some of the sort of emergency extensions to pre-eviction notices that a number of cities have put in due to the current eviction crisis that's happening. So that's coming up next month. And with that, let's get into breaking a lease. And Shana, do you maybe just want to talk a little bit about what student legal services and does as well?
Sure. Yeah. So the perspective I'm bringing today is I represent students in from anything to advising their lease through full representation in court. So we're a full service law firm. We do everything from immigration, criminal law, consumer law, wills, trusts, estates, and it's completely free for any Twin Cities campus University of Minnesota students. So if you know a student, tell them to come use us. And a lot of our work that we do is advising and representing students in housing matters.
Yeah. And so I think we were talking about this before we started, but you said something like what, a third of your cases course of the year or part of the year are about breaking a lease?
Oh yeah, yeah, sure, they sure are. So, if you have a student, you know that they often will sign their lease maybe fall or early winter. And right about, I would say, February, March through August, I spend about a third of my caseload talking through students and advising on breaking their lease and representing them in matters.
Right. Well, we get a lot of those questions as well, and so let's talk about it. I'm going to start here with some sort of general overview and talk about the ways that you can, as a tenant or someone representing the tenant, use state law to terminate a lease early. But there are a couple things to cover first, and I think the primary thing is that leases are binding legal documents, they're contracts. Once both parties sign the lease, they're very difficult to terminate. In fact, I would say in most cases, they simply cannot be terminated without some type of mutual agreement or something along that, which we'll talk about towards the end of the presentation. And there are not a lot of legal loopholes. In fact, I would say there are kind of no legal loopholes, in the sense that often tenants will contact us and they will say, oh, like all of these terms are invalid in my lease, so the lease is void and I want to break it. And unfortunately, that's not really how it works. Void terms and leases, which frankly almost every lease has some terms that violate Minnesota state law, like a lot of the common leases just have stuff that is not enforceable. That does not void the entire lease. Mistakes about typos, those things don't void the entire lease. Um, and there are a couple laws that will do, which we'll cover about, but again, just not generally a lot of legal loopholes. Um, so if you want to break a lease early, if you as a tenant or you're working with a tenant want to break a lease early, there are a couple ways to do it. The biggest one, frankly, is mutual agreement between all parties. A lease is a contract. You can always modify contracts by agreement. If a landlord and a tenant get together and they say, hey, this lease is over today, right now, that's enough. The lease is going to be terminated. You can have verbal agreements to terminate a lease. You generally don't want that. I'm sure we'll talk about that a bit more when we get to the negotiating out of a lease. You generally want your agreements to be in writing, et cetera. But if you have a mutual agreement, that is good enough to terminate a lease. Judges can also terminate leases. This is a bit trickier because for a judge to terminate a lease, you have to first of all have a valid way to get in front of a judge. Like you can't just go in front of a judge, not really at least, and ask them to terminate your lease. So you have to have a valid way to get in front of a judge, and then you have to be filing a type of case where the judge has the power to do that. So, like, you can't sue in conciliation court to get a judge to break your lease. They don't have that ability in conciliation court. But for example, rent escrows, which we'll talk a little bit about when we talk about leverage, maybe for repairs or privacy violations, those are cases where if you have the underlying issue that gets you in front of a judge, one of the things you can ask a judge to do is terminate your lease, and a judge could then terminate your lease. So judges will also sometimes terminate leases. And then there are some statutory provisions that allow a tenant to unilaterally terminate the lease before the end of it. So before the lease is actually over. And I see the question about the event code. We do not have the event code yet, but we will hopefully within the next week or so, is generally about how long it takes. I assume you're talking about the event code for the CLE. So legal reasons to terminate early. I'm going to go through all of these in more depth, but here's sort of an overview. Constructive eviction, victims of domestic violence, criminal sexual conduct, or harassment. If the tenant has a need to move to a medical facility, the death of all tenants, certain things related to military service, not just military service in general, but certain things related to military service, and then certain violations of some local ordinances. And so I'm going to start with constructive eviction. Uh, Tenants call us at Homeline all the time asking to break their lease. It's actually, right now, I looked it up, it's the fourth most common reason they've called us this year. With around 600 calls, it was the fourth most common reason they called us last year with like 1,700 calls. And it's generally in our top five reasons of tenants calling Homeline. They want to break their lease. And the most common reason that a tenant who calls us wants to break their lease is because of repairs. They're saying there's something wrong with their unit. The landlord's not making repairs, so they want to break their lease. There are other reasons, of course, but this is one of the most common ones. And unfortunately, repair issues in and of themselves do not allow a tenant to break their lease. Now, as I mentioned before, and as we'll talk about towards the end, repair issues might allow a tenant to file a rent escrow, and as part of that rent escrow, might allow them to ask a judge to terminate their lease, but it doesn't inherently give the tenant the ability to terminate their lease early. In order for a tenant to terminate their lease early due to a repair or something similar, state law says that the building has to be destroyed or become uninhabitable or unfit for occupancy through no fault or neglect of the tenant. I'm just going to assume no fault or neglect of the tenant for the rest of this slide and talk about, what destroyed or uninhabitable means. The best example of that, if best is the right word, is that the building is burned to the ground or been condemned. Physically, the building doesn't exist anymore, or the city has said, it's a crime to be here. You're not allowed to be here. If you come here, we're going to have the police remove you. Something like that. That's the best example, the clearest example. If you think of like a continuum, that's all the way over here. That's enough to terminate the lease. There's really no question. On the other side of the continuum is something like a broken window, broken screen, a leaky faucet, something like that. Very clearly not uninhabitable. The problem is there's no real line in on this continuum where it clearly becomes uninhabitable. It doesn't require something as extreme as being burned to the ground. There's a court case where a tenant was able to use this statute, which is cited there at the bottom, 504B.131, to terminate their lease because of noisy neighbors. Uh, the court said, yeah, the judge found it to be bad enough, so we're not going to overturn that. The Court of Appeal said that. I've seen judges do it for things like cat urine in the carpet causing very significant smells, etc. I've seen it for other issues that are not as serious as the building being burned to the ground or condemned, or like the loss of heat in winter is another pretty clear one, I think, where if the heat goes out in winter, the building's just unlivable. Like you can't expect people to be in a 30-degree apartment in Minnesota in the middle of winter. So it doesn't necessarily have to get all the way to this end, but the problem here is that the risk for the tenant is really high. The way a tenant asserts constructive eviction, at least in my opinion or experience, is that they do so by moving out, moving all their stuff out, returning the keys, and telling the landlord, hey, I've terminated my lease due to constructive eviction. The lease is over. And the problem with that is once they've done that, there's kind of no going back. The tenant can ask for their security deposit back. Under their theory of the case, they should get it. The landlord is going to say, well, you owe me rent until the unit is re-rented or something like that. And then probably what happens is either the tenant sues the landlord for the security deposit or the landlord sues the tenant for the rent. This issue goes in front of a judge, possibly a jury, but generally a judge. And at that point, the judge, or again, maybe a jury, decides. And that's the person, the judge or the jury, who is making the decision. It's not the tenant, it's not the landlord, it's not the attorneys for the tenant or the landlord if they have it, it's somebody else. And that person has a lot of power. They can say, hey, yes, this was enough. This is the place was uninhabitable. You're free. You don't owe any rent, you get your deposit back. Or they'll say, no, it isn't. And in that case, the tenant owes rent. And so there's a lot of risk. This isn't decided until maybe 6 months to a year later. And if the tenant is wrong, if the judge decides that it wasn't uninhabitable, they could end up owing several months worth of rent. And so there's a lot of risk there. I don't generally advise tenants to do this unless it really is bad. In fact, kind of one of the best examples, or not examples, one of the best sort of guidelines for whether it is bad enough is whether or not the tenant has actually moved out when they called me. If the tenant is saying, I've moved out, then it's probably, they might as well assert this, but it probably was bad enough. If it was bad enough for them that they actually felt they had to leave, probably they were constructively evicted. If they're calling me and they're saying, hey, this problem has been going on for 4 months and I want to move. It's like, well, it's probably not unlivable. Sort of by definition, you've been living there for 4 months. Now, maybe something has just happened that made it a little bit worse and is sort of the tipping point, and so the tenant can argue that. But that's sort of what I look at when I'm hearing this. Shana, do you experience this? Do you have uh, anything along these lines?
Yeah, and I just to echo that this is something when you Google, I want to get out of my lease, constructive eviction is going to be one of the first things that are talked about. And it's very rare. In the past 7 years, I have only had two really strong constructive eviction cases, and I have hundreds of cases every year. And in both cases, one case it was, flood water up to the knees in the on the single floor of the house. So that one was pretty strong. And then the other one was a case where there was such severe mold that they had to rip down all the insulation and run heaters that made the place over 90 degrees for several weeks. And so those were the two cases where we were able to successfully argue constructive eviction because you couldn't sleep there, you couldn't cook there, you couldn't be in that space or use any part of that space. It generally is not enough for part of your space to be unusable. It needs to be the whole space.
Yeah, I would agree with that. Like just having a room out is really tough. Now, maybe if it's something like the bathroom or something that makes the whole
Mhm.
unit kind of unusable, that works. But it is very difficult if the tenant is saying just, oh, the bedroom is cold. I'm sleeping in the living room. It's like, okay, like maybe, but it is kind of like, oh, it is maybe still livable. And again, some judges might find that to be constructive eviction, but the tenant is really taking a risk if they leave. A judge might say, no, this wasn't, you had another option. You could have stayed there while they did the fix or something along those lines. All right, so that's constructive eviction. That's one of the most common reasons that I get asked to terminate a lease, but it is not a very common, I would say, legal ground that actually works. This next one, unfortunately, is also a very common reason I get asked, or a tenant wants to break a lease, and this one does work. I see this. I take multiple of these calls every month, and I see probably tenants successfully do it at least once a month here at Homeline, if not more. And that is a tenant has a right to break a lease if they fear imminent violence and have been subjected to domestic violence, criminal sexual conduct, sexual extortion, or harassment. And I'm just going to say domestic violence for the rest of this, so I don't have to keep repeating that whole phrase, but it is that whole thing. It's not just domestic violence. In order for a tenant to break their lease due to being a victim of domestic violence, they need to both fear the imminent violence and they need to have one of several different statutorily defined documents. These documents are pretty broad, but they include things like a valid order for protection. This is the most common one, a no contact order, a DANCO order, something like that. Um, Something from the court documenting that the tenant is a victim of domestic abuse. So this could be a restraining order. Not all restraining orders do work for this. The information in the restraining order has to show that the tenant is a victim of domestic violence or harassment, but kind of by definition, that is going to be true most of the time. A writing produced by law enforcement can work in some cases as well. And then the last one that I actually see a fair amount of is a statement by a qualified third party in a following very specific a form. I'm actually going to link the statute here in the chat in one moment because I think it's worth looking over. But I also have a website, lawhelpmn.org, has a great fact sheet. If you go to that website and you Google, or not Google, you search the website for breaking a lease, this will come up. It has not just a lot more information, a link to the statute. It actually has a form, the third party qualified statement form that you can just print out and have the person fill out if they can get it. So if they can do that, they can then send the landlord a notice basically saying that they're going to terminate the lease. This also needs to be done in a specific way. And again, the lawhelpmn.org has a sample form. This one is not statutorily defined. There are actually a bunch of different ways the tenant can give the actual notice, but they have to meet certain statutory, or they have to check certain statutory boxes. And so if I'm talking to a tenant, I do actually really want them to use the standard form that Law Help MN, which is basically legal aid, created, because it meets those boxes and checks those boxes, and the tenant will meet the requirements of the statute and be able to terminate their lease if they do this. But it's not without consequence. If a tenant terminates their lease because they're a victim of domestic violence, they still owe rent for the rest of the month. And this is important because the tenant gets to pick the date that they want to terminate the lease. They can say we're terminating the lease today, April 22nd. They can say we're terminating the lease April 28th, April 30th, May 2nd. They can pick the date. But the problem is that the tenant owes full rent for that month. So there's actually a really big difference between picking April 30th and May 1st. If they pick April 30th, they owe rent for all of April. If they pick May 1st, they owe rent for all of May. So even though there's only a day difference there, it can actually end up meaning the tenant owes a lot more rent. And so this is something where timing that can be helpful. Sometimes there's no way around it. Sometimes, it's the 5th of the month, the tenant wants to leave, so they need to leave. You pay full month for that, pay full rent for that month. The tenant also forfeits the security deposit. This is unfortunate, but it is just in the statute. There's no way around it. The landlord gets to keep the security deposit. And it doesn't affect the tenant's liability for debts already owed. If the tenant owes $5,000 in rent, they get to terminate their lease. That doesn't prevent them from terminating the lease, but they still owe that $5,000. And they forfeit the deposit, so the deposit can't be used to cover any portion of that $5,000. It also terminates the lease for all tenants if there is more than one. So if there is more than one tenant, then every tenant's lease is over. They all get or have to move in some sense. A lot of times, the other person is the abuser, and that means that they also have to move. The landlord and that person could continue to rent together, and that would be fine. But if the person there doesn't make a new agreement with the landlord, they are on the hook. Or sorry, they're not on the hook. They are off the hook. They should be moving. If they don't move, the landlord can file an eviction for holding over and actually go to court and force them to move. Um, and then finally, landlords have an obligation to keep the information confidential, and there is a penalty if they don't do so. This was added only like 2 to 3 years ago, I think 2003. It's $2,000. I actually haven't seen this happen too much, but I have seen it happen at least once, a very clear violation where the landlord provided the information to another landlord, and so the penalty was enforced. Um, but there is a penalty if the landlord doesn't keep the information confidential. Uh, Shayna, anything from your perspective?
No, from the tenant's perspective, I would say there's great. I love Law Help MN, and their form is really excellent. But I'll also say there are great advocates that to work with through this process. It's if you are afraid of imminent violence, it's scary to do that and go through this legal process at the same time. And I really recommend using some of those resources um, to make sure that, you're like, oh, this is the form. Oh, yeah, it is April 30th. I should turn that in today and work through that.
Yeah. And if you go to Law Help MN, there's a couple of those resources on the page. Standpoint is also someone we often refer people to, but there are resources out there for people who need this, who can get some help. And they often know the forms as well. And in fact, again, this is where we see a lot of people getting that qualified statement by the third parties by going through these other processes, meeting with someone who has the appropriate license and can talk with them and make that determination. I do see a question in the chat, and I think that it's basically about breaking a lease due to repairs. I know we talked about that a little bit with constructive eviction, but I think we'll save that for negotiating out of the lease, maybe if that's all right. And I do see one other question here, but we'll cover that a bit later. All right, so moving to a medical facility. If a tenant has a disability or medical condition that requires them to move into a medical facility, then they can break the lease with 2 months' notice. It is important that this is sort of two parts. The tenant has to have a disability or medical condition. So it doesn't necessarily need to be a disability in this sort of like fair housing definition of disability, but they need to have something that requires them to move into a medical facility. Um, and then it needs to be a medical facility. And medical facility has a very specific statutory definition. It's pretty broad. It covers a variety of different things. And in fact, I'll just admit I don't know all of them off the top of my head. On a sort of base level, things like nursing homes, hospice care, those are sort of the various broad ones that we see a lot. But you also have assisted living facilities, certain types of treatment facilities, residential treatment facilities, foster care, certain types of that. And so if someone calls us needing to break their lease for this reason, what we'll do is we'll go through that process of number one, first figuring out what's the disability or medical condition that they have, and then number two, are they moving to a medical facility? Does what they want to move to qualify? Because it does need to be both of those things. It can't just be like they had some type of injury, say, a broken leg or something, they're on crutches and they're on the third floor of an apartment and there's no elevator. And so they want to break their lease. That might work in some cases, but it's not automatic that like any medical issue or condition that makes it difficult to live in your unit will get you out of the lease. You've got to go through the process and actually look at the various things and see if you can meet the requirements. And if you get that doctor's diagnosis and you have proof that you're moving to a medical facility and you actually have a plan to move to one, then you can give the landlord that 2 months notice, and terminate your lease. And you can move before the 2 months are up. That's just how much notice you have to give. You have to pay rent through that 2 month period. Is this something you see that much in your practice?
No, I do see in the chat we had a question about it. Did we want to address that now
Yeah,
or?
this would be a good time. So actually, I see two questions. So the first question is, a tenant has stage 4 cancer treatment, lives on the second floor, struggles with stairs and balance issues. Is this the basis to break a lease? They can live alone, don't need a facility. So they certainly, I would say, have a disability or medical condition. Um, but they do have to move to a medical facility. Now, one of the definitions of medical facility is an accessible unit as defined in section 363A 40, which is basically part of the human rights statute and talks about accessible units, meaning an accessible rental housing units that meets the persons with disabilities requirement of the state building code. So there might be, depending upon what the tenant wants to move to, there might be an option there, but that's where you also have the plan to move to one. So they've got to both figure out what they need to move to, and then they've got to have a plan to move to that. And this is also one of those cases where there's I don't want to call it an exception, but there is a sort of a caveat where if the tenant needs to move, the landlord has an option to show that they can provide that thing to the tenant and then give the tenant that thing. So if maybe the landlord has one of those um, uh, accessible units that is available, the landlord might be able to say, you can transfer from your unit on the second floor to whatever this other unit is, and maybe that would work. So there can be, like, that's one of the gray areas where I think you really would need to go through things carefully. Anything you would want to add to that?
We're also going to talk a little bit about this later in the slideshow when we talk about reasonable accommodations, but sometimes moving to a medical facility is a very specific statute that's very helpful for those times when you need it. There's also other options and other levers under both the Fair Housing Act and the Minnesota Human Rights Act that really help. Um, it says it really isn't, sounds like it really isn't reasonable to come. Oh, okay. I can't talk and read at the same time. I'm really bad at that. But I would say that we are going to talk about reasonable accommodations in another area. And I think that I'll come back to that then, because I do think that these are the times that you have a very real need that your housing is not meeting, and there's other options to try to negotiate to meet your needs.
Yeah, and again, we'll come back to that, but I would say the same thing is that often, like we mentioned with repairs, like we mentioned with reasonable accommodations, maybe it doesn't get you to like a actual full termination of your lease, but maybe it gets you enough leverage to negotiate for that, or maybe it gets you part of the way there, gets you enough that you can get the thing that you need, which is the more accessible unit or the repair fixed or something like that. So there may be other options than just full on lease termination, moving somewhere else. And so I see a question in chat or in the Q&A section about the medical facility as well and reasonable accommodations. And again, I think we'll come back to that when we talk more specifically about reasonable accommodations. Um, Death of all tenants. This fortunately does not come up very often, but if all of the tenants die, and it does have to be all of them, if there's two tenants and only one of them dies, it doesn't affect the lease. But if all of the tenants die, then any party to the lease, so this one is actually bilateral, the landlord can also terminate the lease. So the landlord or the tenant's estate can terminate the lease with 2 months written notice. Fortunately, again, this doesn't happen too often, and often even when it does, you don't really need to go through this because either there isn't much of an estate or the landlord and whoever is managing the tenant's estate just comes to a deal and resolves it. But if the parties can't reach a deal and there does need to be some sort of like formal, this is this is the fallback position. This is what we're going to do. You can terminate the lease with 2 months written notice, and the lease will just be over. You won't owe anything else. Oh, hopefully you don't see this very often. Shana, is that right?
We do see this somewhat frequently. It's important to know that that's an when you are on an individual lease, so a lease where you're just renting, say, a bedroom or you're renting the whole unit yourself, obviously that's one thing. When you're on a joint lease, you have to, one of the things I always say is think about if you are able to make the rent obligation by yourself. Um, Unfortunately, things happen, right? And it's something where then you're going through a very sad or traumatic situation and also having to figure out how to do it without the other person who is contributing to rent. Um, so
All right. Military service. I actually do not know too much about this one, for a reason which I'll get to. But tenants in the military can terminate their lease under certain conditions. Basically, they need military orders, either deployment or a permanent change of station, in order to do so. So, they are suddenly on service in another country, or, they're stationed in Minnesota, but now all of a sudden they're going to go be stationed in California or Arizona or someplace like that. In those cases, they can get out of the lease. Most of their dependents, their spouse can get out of the lease. The other tenant may not be able to get out of the lease. It depends. Uh, but the reason I don't know a whole lot about this is because outside of knowing to look for it, if a person is in the military, they have access to some type of attorney, some type of military attorney who is going to know this in and out, and they really should be consulting with that attorney to figure out whether or not they can break their lease. If the deployment or permanent change of station orders are going to be enough, and what the consequences for that are. And they get a lot more help than we can provide as sort of a free phone service. But it is something to keep in mind. If you're in the military and you're being deployed or you're getting a change of station, something like that, you probably do have a right to just terminate your lease without too much of a consequence, if any. Do you see this more often with students? I know when I was going to law school, there were actually a number of active military or people going there as well.
we get it somewhat frequently. I would say that I really lean on their attorneys to work on them because it is sometimes depending on how if they're being deployed or if they're changing station, the rules do vary, especially there's a notice piece of it as well. And you really want to make sure that you consult with your own attorney on that one.
Yeah, yeah. This is one where it's like, oh, look, you guys have access to an attorney who knows this stuff, so that you want to check with them. Um, and then the last reason, sort of, to get out of a lease unilaterally by the tenant is that the city may have a local ordinance that, if the landlord fails to follow, the tenant gets to terminate the lease. The most common one, I would say, is a rental license. It is important to know that the state does not have any rental license requirement. The state does not require landlords to be licensed. They don't require the landlord to get a rental license. And so there's no state law that covers this. However, many cities do have ordinances. In fact, I would say probably most of the cities in the metro area now, and many of the larger cities across Minnesota do. But there are many cities in Minnesota that do not have a rental license, and so rental license requirement, and so this won't apply. But for example, in Minneapolis, the city ordinance is very clear, and the courts have been very consistent in saying that when there's no rental license, no rent is owed, which basically means the tenant gets to leave no matter what. There's not much the landlord can sue for if they can't sue for rent, but also that the lease itself is void. It's illegal, it's invalid, and can be terminated. Courts have said this about a couple other city ordinances as well. And then in many cases, there's no court cases about that city ordinance. So you have to look at the ordinance, you have to compare it to other cities, you have to look at the county and see how judges in that county have ruled on these issues. And so it can really depend on the city, the ordinance, the county, and a bunch of other things. But often, lack of a rental license is a way to get out of a lease. Significant code violations, obviously, if it gets condemned or it's an illegal unit, you get out of the lease. But there might also just be enough code violations that allow you to get out. And then also, some cities may have other examples. Honestly, I think the only one I'm aware about is the Minneapolis specific one that they passed last year, where the landlords have to provide a bunch of mandatory disclosures both before signing the lease and I think within 90 days of signing a lease. I don't actually have this one fully memorized yet. But if the landlord does not provide that information within the 30-day or within the required timeframes, it basically turns the lease into a month-to-month lease as far as the tenant is concerned. And so the tenant can simply terminate the lease with a valid notice. If they give a valid, I should say the valid notice becomes a 1 month's notice if rent is paid monthly, or in some cases it could be 3 months, but they get to get out of the lease. They basically get to treat the lease as if it were a month-to-month lease, and they can terminate early before the end of the year, something like that. Shayna, do you have other ordinances that you have in mind for this?
No, and what you would really want to do is you want to go on your city's website and look up their housing ordinance. A lot of cities have it just right on their city website, and you can kind of click through it. I apologize. This must be the time when my eldest comes home from school, so my dogs must alert me if you're hearing that. I would say the other thing that you want to look for is just because, much like we were talking about, if there's an illegal lease term that it can void your lease, you just because there is a code violation does not mean that it's necessarily a reason to break your lease, but sometimes it is, right? Like there's very serious fire code issues. There's a failure to maintain a rental license, and then those mandatory disclosures are there for a reason. So make sure to check those things.
And then we got a question, which I think I'll answer here. So, what if your self-employment income has changed drastically, like half of what your income was, and you have already had help from, rental assistance, but are still unable to pay? And of course, it doesn't necessarily have to be self-employment. You could lose a job or something. Unfortunately, change of income is not a reason to terminate a lease. It's often a reason you need to break a lease or negotiate out of lease, which is what we're going to be moving into. But there is no right to terminate a lease because your income has changed or because you've lost income. Unfortunately, if you're unable to afford a place, that won't affect your ability to legally terminate. Again, it gives you actually a fair amount of leverage in certain ways, and maybe forces you towards one of these other options, but it won't be enough to actually terminate your lease. And with that, I think we can move into breaking a lease.
All right, great. Um, so when we're talking about, it's time to leave, you need to leave, you're not chained to your house. Like you can move. So one of the things that I always talk about is what are the consequences of the choice, right? There's financial consequences? Is it messy? What does the next steps look like? But you can leave, right? You can always leave. Then now we're going to talk about what does that look like, right? So a landlord has a duty to try and relet. So how they know that you are going to relet this space is because you have communicated with them that you don't live there anymore. And they have a duty to try to put it online. They don't have an obligation to fill your unit first, but they do have to try to relet your unit. And the maximum rent obligation that you will have is either through the end of the lease, or if someone moves in before the end of the lease, when they move in, so the start of their lease term, the landlord does not get to collect rent from both you and another person. Or the notice period if you're at a tenancy at will. So if your lease was a 2024 to 2025 and you've been on a month to month since then, but your notice period on there said 6 month notice period, then it's going to be the notice period on your tenancy at will. So whatever your notice period is, that would be the end as well. And that's under, I think, yep, we have the statute up there, 514. Can I have the next slide, please? Okay. So you may see in your leases things about break lease fees. So break lease fees are a fee that basically says, hey, you're leaving and that's really upsetting and I want money, right? Sometimes I've seen ones that are $200. I've seen ones that are 2 months rent. It really varies wildly. The courts have seen this in commercial leases, and they are considered liquidated damages, so they may not be enforceable. So a liquidated damages is a type of damage that lawyers call when it's really hard to tell what the price is to fix something, right? So for example, if you were a performer and you were supposed to perform at somebody's wedding, it's really hard to tell what amount of money it is to make this person feel whole. That's what a liquid, and then that's why we have liquidated damages. We're like, this is the amount of money we agree to make this person whole is. The problem is landlords get actual damages, rent, um, and you have to pay rent every single month until it's refilled. So the idea that they can have a $500 fee plus rent for the next month up until the moment that they relet the apartment, I find pretty suspicious. Now, sometimes things in leases are called lease break fees, but they're actually more like turnover costs. Those are probably not enforceable, but they might be costs related to repairs, or other things like advertising that are allowed to be charged to you. So you want to look at the words and what they actually mean to know whether or not they're enforceable. Um, I'll also say this. As an attorney and I represent people, this would be one of those times where I'd advise you. I would talk about, could we negotiate a lease break fee? This would be something where if you're working with a landlord, you may be able to negotiate and talk through. You unilaterally deciding it is not going to be enforced does not mean that the landlord won't try to put it on your ledger. So you just want to make sure that you get advice on it and that you make a plan for if you disagree on that. Sam, do you have stuff that you wanted to say about this?
Yeah, I would talk about this because we get this a lot. So obviously, going back to the slide before, um, this is, as you said, often like people just need to move. They're moving out of state for school, for work. They have a family emergency. Someone died and they need to go take care of a parent, a family member. Or, sometimes again, we're talking about repair issues. Maybe it's a close call, but they just don't feel comfortable for their health or safety of themselves or often their children. So they're leaving. It doesn't matter. They're gone. And you know, in some cases, you might be able to argue one of the other unilateral things like constructive eviction. In some cases, you just can't. The tenant's just moving. And so then you're saying, all right, well, what are the consequences? And obviously the most straightforward consequence is rent. It's that actual damages. What you said is they owe rent through either the end of the lease or until the landlord re-rents. Um, but landlords often try to add these other fees on. And my position is always that they are essentially liquidated damages and they're not enforceable, or at the very least, it's on the burden of the landlord to enforce it. And in fact, when you see these really high, like 1 or 2 month rent fees, those may be debatable. But the other thing I can say is I've never seen them upheld in court. I have seen them struck down in the Lagoon Partners, which granted it was commercial, it wasn't a residential case, but I've seen them struck down in commercial cases. I've never seen one that high upheld. But like you said, maybe if it's $100 or $50 or something, and it's really associated with more like advertising or showing costs or something like that, maybe there is a way for the landlord to charge it. And in any case, this would be a question for a judge because exactly like you said, often it doesn't matter what the law is to start with. The tenant's going to have their position. The landlord's going to have their position. The landlord probably holds the tenant's security deposit, so they're going to take money out, right? Like if the tenant's got a $2,000 deposit, the landlord's going to say, well, you owe me rent and you owe this break lease fee, so your ledger is, $4,000. We're not giving you your deposit back. So it is something either the tenant's going to have to negotiate or accept or sue, go in front of a judge and make these arguments to a judge. And in that case, it will ultimately be the judge who decides, is this liquidated damage clause enforceable? How does it go forward? And what are the consequences there? I do see a question here. Does the notice period count if it is to end the term? Example, December 1st, 2024 through December 1st, 2005 needs a 2 month written notice. Tenant wants to break lease 5/31. Does that 2 month notice work for their rent responsibility? So this is a great question. I get versions of this question all the time. Looks like you do as well. No, I mean, I guess technically it would depend on how the lease is worded, but if a lease is a 1 year lease and it says there's a 2 month notice requirement, Unless the lease is very poorly constructed and ambiguous, that 2 month notice requirement only works at the end of the rental period. It doesn't mean that it's a 1 year lease, but either side can give 2 months notice at any point to terminate the lease. That's not a 1 year lease. Then that would be month to month. Once in a while, you do see a lease that is so poorly worded it can be interpreted, but the vast majority of leases, like the NAA, the National Apartment Association lease, MHA's lease, those leases are pretty clear. The 2 month notice only works at the end of the lease term. Um, and with that, we're ready to go to the next slide.
Yeah.
So now I think we get into sort of the meat and potatoes of it.
So, absolutely. We're going to start with the basis that when you both signed the lease, the goal was clear, right? So you wanted to stay for, say, a year. They wanted your money for a year. You signed a document that is written by your landlord to benefit the landlord, and they see it as the full lease term, right? So if you're thinking about it as, oh, it's only like $1,000 a month, right? They're thinking, I have $12,000 in the bank, right? So when we think about it from their perspective, it helps from a negotiation standpoint, right? Um, they may have lease provisions in there to look for. I don't see it super frequently, but sometimes they do, that they'll have like a buyout option. They'll say, you can terminate early if you pay 2 months rent. Or you can, um, if you give us this amount of notice during this season, you can leave early. I've seen those to some degree on different places. And a landlord has to honor their buyout terms that are in the lease agreement. So I have had cases where the landlord it'll say something to that effect in the lease, and I say, great, awesome, we're going to write a letter, we're going to terminate the lease under subdivision 3A of provision 54 on the 42nd page of the lease. And they say, oh, no, that's not our policy to do that. That doesn't mean what it says. And it's no, the lease term is the words on there. And unless it talks about references another document that's attached called an addendum, the words on there are the binding words. So you want to check to see if it has it on there. But generally, in every case I have seen where there's something like that, there is a payment of money in addition to a notice to vacate. So it's some amount of money plus notice to vacate. It could also have some other requirements, such as repaying a concession. So if you got like a free month of rent, or you got some sort of discount, or staying a certain number of months, that you can't use this option until 6 months into your lease. It depends on the lease. It's not something that is very common, but it is something that I have seen in several different leases. So you will want to check to see if there is some sort of buyout option in your lease.
Yeah, and if
Uh,
I could just
yeah.
add a thing here, I would agree it's not very common. There's like the NAA lease has this as an addendum now, which I'm seeing more and more frequently. There is like this very specific addendum that I've seen in a lot of leases, but doesn't show up very often. And what I specifically want to say is that a clause that says the landlord may agree to let you out of their lease at the landlord's discretion is basically that's not what we're talking about. That's basically might as well not be there. That's always true. The landlord can always agree to let you out of your lease. A clause that just says like we'll let you out, or you can sublet with our permission, or assign with our permission, like those are just saying like you might as well pretend that's not in the lease. It doesn't really have any effect here.
Yeah. Um, so a couple things that I like to think about is one, where you're starting from, right? It's easier to negotiate move outs during times when people want to move, right? So spring, summer, fall are easier for a landlord to relet it. And it's those time periods are typically a little bit easier than, say, I want to move out January, and they're like, oh geez, I'm not going to get someone in here for like 5 months. So seasonally right now starts to be a great time. We are starting the moving season. Another one is if you're moving to another of the landlord's properties. So say, for example, you got a new job and they happen to have another property closer to where your new job is. Sometimes you can negotiate moving to the new property. Or for example, you're like, this place is super loud. This place is awful, but I know that their sister property 2 blocks away really is going to be just fine. Being a little bit more creative when you have the problem to see if maybe you can go to another of their properties. That sometimes can work, then they'll terminate your lease and move you into on a full term lease at their new place. I've seen that work quite a few different times. And if you have a desirable property location, layout, or price point, that's something where if it's easier to relet, it is always going to be easier to relet things that are, your 6 bedroom, 4 bath, single family house in greater Minnesota is more difficult to rent out than a 2 bedroom, 2 bath, next to some desirable amenities, right? So location sometimes can play a factor in that as the ability and the likelihood that they're able to re-rent during that period. And
When, if I could jump in here, when
yeah,
you're negotiating with landlords, how easy is it for you to find out like what the landlord's vacancy rate is and if they have other units available? Is that something you're able to get from the landlord or use as a thing to negotiate with?
yeah. So when a landlord has m many landlords now will use online resources, right? So you have the Zillows, you have the apartments.com. You can see kind of the layout of the things that they're going to have. They'll have it on their website typically. And they will tell you when a certain model is sold out. Um, they will also usually tell me if I ask. So you can call and you can ask, be like, "Oh, do you have any have your cousin call. Do you have any 2 bedrooms available? What's the what's the rate?" Right? It's not proprietary information. And it's just things to know kind of where they're starting from. If they have a really high vacancy rate and they're very worried about filling other units, it makes it more difficult to negotiate. And you should want to know that before you start that conversation. Um, go ahead. Were there other things that you've
No,
seen?
that was the main one that I was thinking about for this section is like the vacancy rate and how easy it is. And we're not really dealing with subsidized housing, but that's something that I also think like there are other considerations for a tenant in subsidized housing breaking their lease that are very important that you need to think through. But if you are, for example, in Section 42, that unit probably will get re-rented because subsidized housing is valuable. People want it. Same with project-based Section 8. Like if you vacate a public housing unit or project-based Section 8, it's going to get filled. Like those things are not vacant generally for very long. But that is sort of a little bit outside of what we're talking about here, and there's a bunch of other considerations for tenants in those situations.
And so, absolutely. Here's what I'll say. Unfortunately, often the common deal is going to involve a sum of money. And if you're trying to move, moving's really expensive. So I understand when people come to me and they say, I need to leave and I don't have money to give them for a place I'm not living. Fundamentally, I understand not a lot of people have extra money to like be paying rent and moving and doing all of these things. But that is going to be often the name of the game, right? Is some amount of money and some sort of move out term. A really common one that we're able to work out is if you're willing to move out maybe mid-month, so they have a little bit of time to do some turnover, but still paying the full month of rent. Or staying until a new tenant is found and advertising your unit on social media. That's like a subletting type thing, or just like helping promote that unit being filled. Those are usually something that the landlord is open to doing because it doesn't, the issue with that piece is you're still staying until a new person is found, which puts people in a bind when it's time to leave, right? You're not really, you're like, am I moving next month? Am I moving the month after? I don't know. Could somebody please move into my unit? But that's something that if you're on the long-term affordability piece, like you're looking at it, you're like, I've had a change in circumstance. My roommate moved out that was supposed to pay rent. Those are things that are helpful to kind of start that process moving. I would say that having open communication is really important and coming in with a realistic expectation. Sometimes people will come to me and they'll say, well, I asked them if I could just leave and they said no, and they're very surprised. So, and I think that that's reasonable. I think you chose your landlord because you trusted them and they are reasonable people. So you're just going to come to them and you're going to kind of say, these are the types of things I want to be thinking about. Could I get the next slide? So here's some different leverages. Your lease may have a sublet agreement, like it'll say can't sublet unless we agree to otherwise, or they'll have a subletting policy. You're going to want to know that before you find a subletter because sometimes they will have different standards for subletters than they would for you. For example, they might say, they have to have a certain income level, or you have to remain as a guarantor for your subletter. Those are pretty common things. But it's still better, assuming they pay rent, to have someone else moving in than you doing that. Often there's a fee associated with having a subletter as well. You pay like a $200 sublet fee, something along those lines.
Can I jump in here? Do you see this a lot? Because I don't. You see people like doing something interesting. Is it related to student housing and like
Yeah.
that type of thing? Okay.
It is very common. I by the end of a lease term, if it's for a house and it's a joint lease and there's 8 people on it, third of them are crossed off and somebody new's on there. People come and go. There are some risks along with subletting that I brought up before, which are related to, are you responsible for the subleases, like rent if they don't pay or if they cause damage to the unit? That's something you want to know about. But also, there's usually some sort of fee. You have to pay that. The only fee that typically is not enforceable is you cannot forfeit a security deposit. Minnesota law is very specific under their provisions on what can be taken and deducted from a security deposit. So if you see something that says you forfeit your security deposit if you find a subletter, typically that's not enforceable. You may choose to let go of your security deposit because you need to get out of there, but you should know that that's not a required piece of that or necessarily a legally binding requirement.
Yeah.
Um, you can also request to move out if your building is undergoing renovation or they're looking to sell the property. Typically, that's just a timing piece, right? It may also be the reason why you want to leave, right? If they are showing your property all the time, if they just did all of the renovations from the floor above you and it was super loud and obnoxious, not necessarily constructive eviction, but it was not great time, then that's something that you definitely want to, you can talk to them about because it might be something where it's convenient for them to have you out of that space. So thinking about that is helpful. And then this is the piece that I would say is really helpful for starting a conversation that has stalled. So if you have talked to your landlord and you said, I really need to find someone, they say, great, find a subletter, and you're having the hardest time because it is February and you cannot find anyone and you are facing some other barrier. Leaving an honest online review of the property, if it's honest and unflattering, is often a way to start a conversation. I will say landlords are, both corporate landlords and local landlords are very, you know, sensitive to their online presence. And this is ways to often people are wanting to leave their place due to the condition that they are in. This is very helpful. So if you have I say this, you do the show don't tell. There is a risk of it getting taken down or being sued for defamation if you say things that are lies and things that can't be proven. So what you want to do is you show don't tell. For example, if your landlord has not dealt with a mice situation in your unit and you've been dealing with mice for the past 4 months and it's not enough reason to get out of a lease in of itself, you put a Google review on there. You say, I have contacted management 6 times in the past 4 months to try to get mice out of my unit, and I still see mice daily. That's all you put, and you put a 1-star Google review. I'm going to tell you, as someone looking to rent, I don't want to live in an apartment that's had mice for 4 months. And I would be very, very, very concerned about the quality of that. Every time I have helped a student write an email, write a review that's honest, factual, doesn't use the word slumlord, doesn't like put any characterizations into it of they're the worst person ever and I can't believe it, they're crooks, and just is very factual, we're able to start a conversation very quickly thereafter. Sometimes the right people don't even know about the problem, and you can get the problem resolved and often use it as leverage to get out of the lease. Because if you're to that point, I always say, both parties often are to that point where they're ready to start negotiating a lease termination at that point. Documented significant habitability concerns.
Can I actually jump in
Yeah,
on
go ahead.
I think you
Mhm.
said this, but where are the best places to leave online reviews? Because this is something that I think often tenants and even I struggle with is where do you go? Where do you go to review a landlord? There's not always, those places don't always seem to exist.
Yeah. Well, you can Google review the apartment. So if you're in an apartment, it's more difficult for single family homes. But I would say the apartment that do a Google review there or the management company. The management company will often show up as well. If you have an outside manager, you can do that and put it on there for them to see. Another place to talk about it that I see, and I serve, generally speaking, a younger population. Reddit's really popular. That's often where renters go to go find information about a geographic area that they're looking to rent. So that can be a really useful tool to talk about things in that space. Th those would be probably the top places that I see. Do you see others?
No, honestly, I would say Google reviews, those are the primary ones. And in fact, this is the thing where I think, and some of it might be the like all across Minnesota, it might be harder to find some places review, but like tenants will come and be like, I left a negative review at the Better Business Bureau. I don't think that has really any effect. I'm not sure if anyone looks at that. I think that Google reviews probably are the best. I actually hadn't thought about Reddit. I didn't realize that people use that for checking landlords. And it sounds like there might also be some difference when you're in like apartment complexes versus single family homes. Those types of things are just easier to review because I think it is tough. If you're renting a single family home from an individual owner, there may not be a place necessarily to review, but I think you're saying that for like businesses and apartment complexes and those types of things that get marked on Google, like you're just going to be able to leave a Google review.
Yeah, absolutely. And typically speaking, um, I have used the Better Business Bureau before, and results vary. You can also, I didn't put this on here, but something that's helpful is if you have some sort of issue that is related to like a legal basis, right? And the first thing that always comes to my mind as a housing attorney is going to be like habitability issues or safety issues. Leaving, if you, the Attorney General's office has, yeah, okay, first time, I'll come back to that. Thank you, Christina. Um, the I don't remember anymore. I'm sorry. We're going to go back to what Christina was saying, which is Reddit has a list of the worst and best management companies and they compare with each other on threads for good resources. Yeah, no, Reddit's crazy. I'm a big fan. It's something that you can do when you're doing your search for your next place. And it's something that especially people who use Reddit are pretty attuned to. It has quite a bit of a cult following. Um, Oh, the Attorney General's office. That's what I was going to talk about. So I'm talking about reviews, but you can also report any complaints to the Minnesota Attorney General's office using their tenant complaint form that's on the Attorney General's website. That is also a leverage point that you can use to bring up any like habitability or legal issues related to your property. And often the Attorney General is not going to represent you. They represent the state of Minnesota, but they may send a letter to your landlord. They'll use your name, so that's something to be aware of. Thank you. And they will say, hey, Jane reached out to me. This is what's going on. This is the statute. Please do a responsive letter to us. You want to know what would scare me as a landlord is a letter from the Minnesota Attorney General's office. Often that is something that will get either your issue resolved so you don't have to break your lease or can start a conversation for, hey, this is, you are dealing with this issue and you are not handling it in the way that I find appropriate. I'm going to have to keep moving forward. Can we at least start to have a lease termination conversation? So, documented significant habitability concerns is probably the number one reason I see people wanting to get out of their lease. Obviously, life's changed, financial situations change, but the thing that makes someone say, I just want to leave when they were planning to stay there for a year is typically habitability issues. And it seems very unfair that you have to go through a legal case to try to get a landlord to do their job because their job is to provide a place that meets local code and state code related to habitability issues. What I often start this conversation with people is that you need to document these things and you can use them as a leverage point. If your plan is I'm over it or I may be over it in the future if they don't take care of it, we start the documentation early. So that way you can say, I contacted you in January 1st, January 15th, January 30th, February 10th, and you have this whole series of pieces of, how I've tried to work with you. That book right there not only can be used in some sort of legal case moving forward, which is very, very important that it's documented, but it's also something that when you're talking to the person that you may be leveraging for a lease termination, you have receipts, right? The person that you're working with for a lease termination may or may not be your local property manager. Sometimes their property manager will say, nope, I don't do that. You're gonna have to talk to your regional manager. Your regional manager, or whoever this corporate person is, or the uncle to the person who's the handyman at your place, may have no idea that you've had these serious habitability issues. And that's something where if you have it documented can be used as a leverage point to be like, hey, you know, I've been trying to work with you for a long time here. I think this relationship is not working anymore. I don't want to go to court. I don't want to do all of these things with you, but I'd like to start a conversation. Um, and often implicitly, but sometimes explicitly, that involves suing or threatening to sue your landlord. My advice when we talk about this, however, is when you say you're going to sue a landlord, that is not a casual thing to say. It will escalate the tensions, right? So be prepared. That's okay. You know, you should also be prepared to sue. You shouldn't say, well, I'm going to sue you. And then 2 days later, you're like, I think I should have another conversation with them. I'm actually not going to sue them. Because once you say it, you kind of have to do it. So you have to, if you're going to use this as a leverage point, that maybe they have significantly violated your privacy repeatedly, they have really bad habitability issues, there's other code violations, and those things have started to happen. Those are going to be things where you would say, hey, I'm going to sue you. And you have to actually do it if they're not willing to negotiate at that moment. Because I would say I give this like a 50-50. Half the landlords I work with, I'm like, hey, if we can't work something out, we're going to have to go to court. They say, see you in court. And I say, very cool. I will see you in court. And the other half say, okay, let's start to keep going on that. I'll say the main piece here when you're negotiating with all of these different issues is that you're realizing that you're working with a person. So you will start to notice things that they may or may not be rational about and things that you may or may not be rational about. So I think that what's really important is you're really clear in your communication. So that way, there's not any misunderstandings. There's not, you know, we don't need to start screaming. That doesn't get us anywhere. They're just levers for lease termination. If you're going to do the sue, threatening to sue, and documenting significant habitability concerns, what I always say is it's time to be the most annoying you've ever been in your entire life. And it's great. You can be very professional. In some ways, it's very cathartic. You'll be like, it is Monday. I'm requesting an update on my repair issue. And then 3 days later, it's Thursday. I haven't heard from you. Please respond by Monday. It's Monday. I haven't heard from you. Or following up from our conversation on the phone on Tuesday, and you lay everything out. One, you're building your case for if you do have to sue or threaten to sue that landlord. And also, it's something that eventually people are like, I'm spending so much time working on this. Let's just make a deal. Let's make a deal. We're both clearly unhappy at this point. And that's something that it's not a legal basis because you're asserting your rights. You're not bothering anybody. You're just trying to get them to do their job. And they're like, oh, okay, they're actually going to make me do my job. I don't know. Maybe they're just unhappy. There's no pleasing this person. And then you can start to make a deal. What else have you seen?
I mean, so I would say everything that you just said is very true. And as I said before, the most common reason that people want to break their lease when they call us is habitability concerns. Like the number of emails that I get or calls that I get on like literally a daily basis of there's mold, I want to break my lease. There are mice, I want to break my lease, et cetera. Like those are the most common things. And I would even expand it to one of the questions that we got, pre-submitted questions was, my neighbor is smoking and I want to break my lease, which is a type of habitability concern. It's a little bit different than like a clear code or repair violation. But like these types of things are very common reasons to want to break your lease. Noisy neighbors are another reason. And, all the things that you said, I think are exactly correct. You try to negotiate, and then at some point, if you can't negotiate, you either have to, well, you have to stop negotiating because it's not going anywhere. So you either have to accept the situation as it is, or you have to take the next step and go to court. And there's a question here about, what counts as suing or what is suing. Is escrow the same as suing? So there are many ways you can sue the landlord. You can sue in conciliation court. You can sue in district court. But I would say that rent escrow, when I talk about suing, at least I am including rent escrows. There are also emergency tenant remedies actions for emergency repairs. And I think that these two cases, emergency tenant remedies actions and rent escrows, are the two most common cases I see, with rent escrows being the bulk of them, of course, because you can always do that for a repair, whereas for an ETRA, it has to be an emergency. But rent escrows are one of the most common reasons that you can sue a landlord, or most common ways to sue a landlord. And again, going back to what I said at the very start, when you're in front of a judge for a rent escrow, one of the explicit things that a judge can do in that case is terminate the lease. And the judge has discretion to do it. And all of a sudden now it's not just the constructive eviction standard of unlivable. It really is just the judge thinks it's fair or right or okay to terminate the lease. And it's been a while since I've looked at this, but I did a big survey of rent escrows a long time ago, and lease terminations was the third most common thing tenants got out of rent escrows. The most common thing was repairs, of course, then some type of rent abatement. But the third most common thing was lease terminations. And to your point of the landlord saying we're just not going to work with you, uh, many landlords I find change their mind on that when they're actually in court. Once they've had to hire an attorney, once they've had to show up at court, once they understand that the judge is actually going to take this seriously, and like at a minimum they're probably going to have to make some repairs. um, at that point a lot of landlords will say, okay, you want to leave, let's just leave. And it goes to what you said, I think, of like being as annoying as possible. Like they're spending so much time at this point. They're like, when I take into account having to hire an attorney, having to go to court at least once, probably 2 to 3 times in a rent escrow. It's annoying for tenants, but it's also annoying for landlords. Like having to do all this work. Maybe I really do just not want to deal with this, and I will let the tenant out. And you like when I looked at settlements in rent escrows, one of the most common things in a settlement in a rent escrow was a lease termination. And especially for neighbor violations, because that was one of the questions, and we can talk about it specifically at some point here if someone has specific questions. But winning neighbor violation cases can be difficult in a rent escrow. But again, you get to that being as annoying as possible. A lot of times, what do you need? A 60% chance of winning as a tenant? That's a 60% chance the landlord loses. And that might be enough for the landlord to just say, okay, we'll let you out of the lease. This is not no longer worth the cost of fighting. So I do think, like you said, you don't want to just bluff. This is not the first thing a tenant I think should go to. But if they've hit a wall and they can't negotiate, and the landlord is just stonewalling and saying we won't do anything, then if you've got an underlying concern, or you can raise an underlying concern as a tenant, going to court, especially through a rent escrow or ETRA process, is a very, very good way to get out of the lease if that's your primary goal. And I think going back to the earlier question by Christina Miller about habitability and good repair, again, this is sort of the answer to that as well. If the landlord isn't holding up their end on repairs or habitability, it may not get you out of the lease as a tenant, but it does let you file the rent escrow. And often filing the rent escrow really will get you out of the lease if that's your goal. If it's not your goal, it doesn't have to. But if it's your goal to get out of the lease, I think rent escrows can get you that either through the judge or more often just through negotiating with the landlord.
Okay. So the other things to think about are what we talked about the ordinances, if they've failed to meet a local ordinance or terminated the lease, if you have some sort of legal basis, but maybe you want a smaller notice period or you want to negotiate things around that, that's another place where you could use it as leverage to terminate your lease. Also, evidence, I'm going to say these next three things are just very fact specific. So one's going to be evidence of retaliation by a landlord. So if, for example, you have called the city inspector and the city inspector said, okay, I'm going to come out on Tuesday, and your landlord gets notice that the city inspector is coming out and they have either, you know, taken an adverse action against you. So done something, everyone else gets to do X and you no longer get to do X, charged you a fine or fee, done something, or said, you know what? I know that I gave you those papers to renew your lease. I don't want to do that anymore. So if you have some sort of retaliation evidence, that's a really strong legal case that you would have. So you would really want to have any evidence of that and to be able to talk about that, right? To be able to talk about what retaliation has happened in this space. That's really strong lever for lease termination. It doesn't make them look great in court. That's not something they want to do. we talked a little bit about this earlier in the slideshow, but this is one of the most common things outside of habitability issues and used in habitability issues that I use as a lever for lease termination. Sometimes you will have either a physical or mental health reason why your housing isn't working for you. And that can be, it's, you know, the someone who's attending this CLE was talking about cancer, right? They're like, I have mobility issues due to cancer. They can request a reasonable accommodation for their housing to meet their needs, such as to be moved to if if stairs are an issue and you're now having mobility issues, or you can't use part of your apartment like your bathtub. You can ask for reasonable accommodation to get an accessible unit on a lower piece. Um, you can also use it for repairs. So, for example, I had a student who had a very serious mold allergy. So, while the traditional process of rehabbing a unit for mold would work for a lot of people, it did not work for her and her respiratory conditions. However, I was able to put in a reasonable accommodation request to terminate her lease, saying, while you're doing whatever you need to do, that's great, but like this is a very serious medical piece. A reasonable accommodation typically it does require a provider to give it to you. It can be a mental health or a MD that says that they treat you for this. And then it also, your provider has to say that they believe that you should be able to terminate your lease or need a certain amount of accommodation for your lease. Those are the things that you need to have in order to put in a reasonable accommodation request. After you put in that request, the landlord has it's an interactive process. They have time to review it and to try to fix it if they can. So if, for example, they're like, yeah, we can put you into the lower unit that's accessible and you can get into your tub. Or it can move you into a unit in a different area that doesn't have any evidence of mold, right? So they're allowed to accommodate you without terminating the lease, but they may use as their lever a lease termination, right? So they might say, you know what, we will let you out of the lease. This is something that you can do and that you request through that. Um, I will say there's an exception to a reasonable accommodation request, which is a landlord does not have to honor a reasonable accommodation request if it's an undue burden. That's a pretty high standard. Often, landlords, it's if when the law was written, it was meant to be for landlords may not be able to put in an elevator in an old building, right? It's like it's impossible. It'd be too much of an undue burden because the building just cannot fit an elevator. But often they can accommodate you and you can go back and forth in an interactive process. It's really important to put your reasonable accommodation request in writing and to have that letter from the landlord. Do you see reasonable accommodations at Homeline?
We do. I mean, I would say that there's a couple problems with reasonable accommodations. First is what you said, which is the landlord can say it's an undue burden. And when you're talking about fully canceling a contract, if the accommodation request is just a flat out, like you start with flat out lease termination, um, that can be really difficult. And I'm not actually aware of a lot of cases going either way on that, which makes it difficult to predict what the outcome would be if the tenant did have to sue. But I think that a lot of the other things you said are a lot easier to request and a lot easier or a lot harder for the landlord to reject, like transferring to another unit, making rule accommodations, et cetera. And so when you start asking with those, I think often what we find is sort of what we said before, which is all of a sudden the landlord starts saying, well, moving from unit A to unit B, like maybe it doesn't matter to me if I just let the tenant out. Like the landlord starts to see, oh, maybe it really isn't as hard for me to let the tenant out of the lease as I thought it would be. Because they're like they always sort of start from the position that letting the tenant out is just this huge burden, impossible for them to do. And I think if you start there, that's a problem that it can be hard to overcome. But if you don't start there, if you start with other requests, um, you might just get to the lease termination at the end of it, if that makes sense. And then I do just want to point out, mostly we're talking about private housing here. There are actually different requirements if you are in certain types of subsidized housing. Certain types of subsidized housing might require the landlord to transfer you or let you out of the lease, et cetera, for certain types of reasonable accommodation. So it could change if you have a subsidy versus if you're just renting in a normal private landlord who's not a government actor or receiving a government subsidy.
And then the last one is, and this is much like threatening to sue your landlord, is just threatening to break the lease. So if you are going back and forth and you are close to the end, right? You are close to deciding, you guys aren't that far apart. You're like, look, at the end of the day, I might just leave and I might just turn in my keys in a couple weeks. So what are we going to do? Can we make a deal or no? Right? Um, they may say, nope, that's fine. Goodbye. We will, use our statutory obligations to actually to relent, but we're going to come after you for all of the rent until then. However, sometimes it does get them going where they're like, okay, well, if you're going to leave anyway, we'll take your $500 now because they don't want to put it in collections. Nobody wants to put things in collections. It's work for them too. Um, and oh well, if you're okay if we do X or let's make a deal around Y. Sometimes just saying, I have to leave May 1st. I will be in a different state May 1st. Let's make a plan is helpful.
Yeah, and I would jump in here and say that, it is risk, and so this I think depends on how risk averse you are as a person.
Yeah.
Um, but most landlords do re-rent in a month or two. This is not guaranteed, and you have to take into account the other things that we talked about, like price, the location, and all of those things. But re-renting in a month or two is fairly reasonable. That's why landlords require 2 months notice in most cases, is because they think, oh, I can probably re-rent in 2 months. And so, a lot of these break lease deals are maybe like give 2 months notice and pay a fee of 2 months. Sometimes, especially if you don't really have a choice, like you are going to have to move, it can just be, I mean, completely acceptable to say, take my $500 as you said, or I'm just going to take the risk. I'm out of here. I'm giving you nothing. And just trust that the landlord will be able to re-rent. Um, and there are some real risks to that, so it's not something I would say you do lightly. And again, I think it is sort of, for a lot of tenants, preconditioned on they don't have a choice. Like, it's going to happen no matter what. They are moving, they have to move. Then you can say like, this is like, it's sort of an ultimatum. I can give you X amount of dollars, and that's a benefit for you, landlord, because if you don't take this, my fallback position is I will just leave. Like, there's not a choice for me. I am moving. So, make a deal and take my money, or I'll roll the dice and hope that it works out. I'm with the understanding again that for a lot of tenants, they might not be collectible. Like, a landlord might not be able to collect on them, depending upon the situation. If you're talking about income loss or those types of things. And again, I want to be careful here. This is not a thing that you should just do without talking to an attorney, without making that decision. But it is, I think, real leverage, because especially with the 504B.154 that was passed a couple of years ago, landlords have a legal obligation to look. If they don't look, it actually it doesn't follow the normal mitigation rules, at least as I read the statute. It terminates it immediately. If the landlord doesn't look, then the lease is over when the tenant abandons the unit. And that's some really strong leverage. Landlords have to look in places where there's turnover, there's people coming and going. Maybe the sort of the standard deal of 2 months notice and a 2 month fee is not really the reasonable deal. And this threat is actually, I think, going to get better results. So it does depend. It is very case by case, though. I think it's not just something the tenant should assume or should do for the fun of it, or think that, oh, this will work out for me. Um, is this no, we've got a couple more slides. I think you've talked about this, but before we get to just general questions, we've got one last slide.
Oh, yeah. And this is just more of like your tips for when you're going through this process. As you've kind of heard from us, it's often very dependent on who the other person is, what you're renting, and what the situation is, right? I will say, in 100% of the cases I have asked for a lease termination, they start with no. So it's okay. Don't get flustered. It's okay to ask clarifying questions and to advocate. And knowing that going in sometimes helps. That's what I always tell students. I'm like, we're going to start with no, and we're going to go from there, right? And we're opening the communication. It's really important to communicate and follow up in writing whenever possible. Often the best conversations will be in person, and you may know that, like when you're talking to someone, that's where things are happening. But what's said in person needs to be in writing. And it's okay to have a conversation down at the front desk, go upstairs, and then write an email that says, thanks for talking to me, Cindy. As we discussed, I want to leave May 1st. And we said that you were going to do X, Y, and Z, and I'm going to do LMNOP. Thanks so much for your time. I look forward to working with you. Perfect. Great. You have now captured that in an email that we can take in case anything goes sideways and Cindy doesn't work there anymore and John says, I would never make that deal. Things like that. You really want to make sure that any lease termination paperwork provided to you, that you read it and you read the terms really carefully. Things you want to look for are any liability for damage to the unit, if they're going to say you're going to pay certain things, any liability if someone's coming in on your lease, like a subletter, that could potentially be there. And then anything in there that's related to what kind of reference they're going to give you. Often you'll want to see something in there that they will give you a neutral rental reference. Neutral means not good or bad, right? If it says something like they will give a good rental reference, all the better. But often it'll say something like neutral. And then discuss the security deposit and make sure you give the forwarding address. So under security deposit law, they have 3 weeks from the time that you provide the forwarding address to send your security deposit on. So if you've negotiated and when you're negotiating, you're like, hey, and by the way, I paid an $800 security deposit. Here's my forwarding address. You gave that to them in writing. Make sure you do that because that's what starts the clock. And then if you choose to move out without an agreement, make sure to turn in the keys and communicate that you've surrendered the unit, again, in writing. Really important to email that. That's really key information. You What starts their requirement to start looking for a new person is knowing that it's been abandoned so that there is nobody in there. You're good to go. You don't want them hemming and hawing for weeks and weeks while rent is running. You want to make sure that they know you don't live there and you've provided the keys back to them.
Yeah, and also, if the landlord knows that the unit is empty and that it's been abandoned, they should not be filing an eviction. Some landlords will do so anyways, but that helps as well and can prevent an eviction from going on the tenant's record. So if the tenant knows that they're abandoning, they really should just leave, turn over the keys, give that notice in writing so they can prove they did it, and then hopefully that resolves that issue. And so I think with that, we've got a couple minutes here for questions. So I think we answered this one, but if they say they're moving to a medical facility, is a reasonable accommodation, does that cut the 2 months notice short? Shayna, do you want to just clarify that maybe?
Yeah. So these are two different areas of law. So they have a funny overlap. So if you are moving into a facility, you have the 2 months notice requirement. That is a much more straightforward way to get yourself into the facility and limit your liability. As we talked about reasonable accommodation, it's an interactive process, right? And it involves the landlord being able to do things like, well, I could do this for you here, and we can move you into this place, or we can do this. They have a series of ways that they could try to meet your needs without terminating the lease, whereas the statutory right for moving into a facility lets you terminate the lease. So if the goal is to do that, I recommend starting with that piece, knowing that you do have to pay the 2 months rent. The interactive process where they're considering your request for a reasonable accommodation often takes 30 days. And during that time, you still have to pay rent. So I would say that if you meet the standards under the statutory requirement, I would advise to use that route. The reasonable accommodation route is when you're doing something else, right? You aren't moving into a facility, but you do have certain needs. The space doesn't meet your physical or mental health needs. So that would be when you would want to use that interactive process to either make that place meet your needs or be able to potentially terminate the lease.
And then, can a landlord ban winter move-outs? A friend's apartment lease states that the tenant can't move out in the winter. I assume winter is defined, and that, according to the landlord's lawyer, it's legal to ban winter move-outs. This is a little bit different than the things we're talking about here, but I would say, just very briefly, it can be possible to do it if done correctly. There are a number of things that landlords often mess up, though. So I see these bans, and I would say they're enforceable about 50% of the time. And about 50% of the time, they're not enforceable because the landlord didn't write it correctly. So that would be something I think that you should have the tenant either contact our office, or if they're a student at the U of M, they could contact Student Legal Services and get a more specific answer to their question. You may have addressed this with the liquidated damages question, but what are your thoughts on reconciling the duty to mitigate when a tenant leaves and a landlord who also charges a penalty or fee for moving out early? I think that is what we were talking about with the liquidated damages question. So I think I'll mark that one. If you would like to ask a follow-up, feel free to do so. If I sign a mutual termination agreement that says I forfeit my security deposit in exchange for ending the lease early, is that enforceable? Shayna, I'll let you answer that one.
So Minnesota law says that there are certain things that you can't waive your rights to, right? They're unwaivable rights. Security deposit law typically is that. However, it's still your money. So if you have gone into and negotiated a settlement agreement and that's what the term is, you're like, I don't have $500, but you can take my $500 security deposit, and you knowingly and willingly and voluntarily signed that, it probably is enforceable. That being said, it really matters how it's written. So I would definitely ask for advice on that. I've had a couple cases where there was some questionable wording and pieces, especially if it's, I get more suspicious if it's you forfeit your security deposit and you pay this and you and LMNOP and there's all these other conditions also. So it really depends on what the full package looks like. Generally speaking, security deposits are only supposed to be used separately and you don't forfeit them, but using them as leverage for payment may be separate.
And then we're at time. Do you have just a couple more minutes here? Is that all right? All right. So let's try to get through some of these last questions then. Can a resident ask for proof of undue hardship regarding accommodation request? So I assume what you're saying here is that the resident has made a reasonable accommodation request. The landlord is saying this is an undue hardship. What is the resident allowed to ask for at that point?
That's a great question. So, generally speaking, you can have an informal conversation. Say you asked for it. You're like, it's an undue hardship because it's too much money and, as a landlord, I can't afford it, right? You can ask for, did you get quotes because I needed this repair? Or if I'm trying to break the lease, is that like, really that's how many units do you have that are vacant, right? So what's your vacancy rate? Those are things you can ask for. You have to go to court in order to force another side to give you something, right? But Minnesota has a great human rights department that you can submit a complaint through and go through an informal process if you would like to explore that. If you feel like your reasonable accommodation request was not considered or was improperly considered or took too long, those um, those are things that they will explore and they may advocate for seeing more information and you may get it that way.
Yeah. If a resident is moving to a medical facility for only 3 weeks, do they need to give more than 30 days? Uh, it does have to be, I might be wrong about this, so please correct me if you know otherwise. It has to be a more permanent transition. Like 30 days, I think is too short. That is something though that I'm not 100% positive on. Because there are some cases where you would move for less, but again, when you look at the list of medical care facility, hospice care like that, you're not generally coming out of hospice care, nursing homes, again, not generally coming out of nursing homes, supervised living facilities, assisted living facilities, and you have to show the landlord that you have this plan. So I don't think in most cases just moving for 30 days would even meet the requirements of the statute. But I could be wrong. Maybe I'm not thinking of something here, or missing something. I don't know. Do you see tenants use this for shorter periods of time?
I haven't had a case like this before. I do think it's interesting because sometimes people use nursing home is listed on there, and
Mhm.
sometimes you need to have a surgery and you don't have someone to care for you post surgery and you are in a nursing home for 3 weeks. Theoretically, there could be fact patterns that fit that case. That's not the intention of the law, and it may be that would be a very difficult one. You would probably want to call Homeline
Yeah. Yeah, and
to
you would
talk through
still
that
have to
one.
give 2 months notice. And so then
Yes.
you also, I think, run into the question of like, is it even worth it for the tenant? Like, do they want to fully terminate the lease that they're living at because they're going to someplace for 3 weeks? Like, will they need some, like, where are they living after they come out? So yeah, I think that would be pretty fact specific, and you'd have to look at the condition, the place they're moving to, what the plan is, what's best for the tenant, um, and go from there. Uh, and I think there's one that's sort of question, which I think is maybe a bit too close to giving legal advice in the general chat for having what you said on an application. Feel free to contact us if you were a tenant there. It sounds like you were. Feel free to contact us directly, and we can talk about that. But I don't want to answer that question live because I just don't want to feel like I'm giving legal advice to a specific thing. And then there's one last question, but it's just what if they abandon under 504B.154? I'm sorry, that was probably to a specific thing we said, and we missed that response. And so I'm not sure what it's referring to anymore. But I think at this point, unless anyone has final questions, I'm going to say thank you all for coming. Thank you, Shana, specifically for agreeing to give this presentation, for all of your expertise. And with that, I think I will end it. Thank you. Have a good day.